Christy Wilson of the Roswell Police Department pulled over Georgia resident Sarah Webb for allegedly speeding on her way to work in Booth, Georgia. After Ms. Webb pulled over, Officer Brown vehicle.
Stay in the car. Officer Brown, Roswell Police Department. You know how fast you were just going, ma'am? I'm so sorry. I'm late. So you could go over 80 miles per hour on 92? No, ma'am. You have your driver's license and your insurance card? Turn off the car and pass me the keys, please. The ground's wet. It's been raining. You're going over 80 miles an hour on this type of a road. That's reckless driving, ma'am.
This is what the trick is. I'm trying to look it up. I don't have it turned off.
Give me 1 second. I'll be right with you. Go for it. Okay. She was going like almost 90 down there. She flew past me. I had to get up to 90 to touch her. My CAD's not working. Is yours? Can you see if can you check the tag too? I'm gonna have to restart this to see what video is. I'm gonna take her probably for reckless. She flew past me going probably 80, 85 on 92 in the wet road. So she's running late for work. I had to get up to 90 to catch her. What do you think? I mean, I don't have any speed restrictions at the same time, but...
Here, Officer Brown admits that she was not equipped with any speed detection devices to get an accurate measurement of Webb's speed. While the law varies between states, in Georgia, individuals can be convicted of speeding or reckless driving based purely on an officer's visual estimate of their speed. Georgia's speeding laws are found in Section 40-6-180 of the Georgia Code. Quote, no person shall drive a vehicle at a speed greater than is reasonable and prudent under the conditions, and having regard for the actual and potential hazards then existing. And Section 40-6-181, which states that no person shall drive a vehicle at a speed in excess of certain maximum limits. In the 1992 case of Brown v. State, the Court of Appeals of Georgia determined that an officer's testimony of his visual estimate of the defendant's speed was legally sufficient to support a speeding conviction, holding that, quote, opinion testimony of an eyewitness may be used to establish speed, credibility being the jury's determined. And such evidence is sufficient to authorize a jury to conclude that speeding laws have been violated. Similarly, in the 2002 case of Stone v. State, the Court of Appeals upheld a conviction based solely on the visual estimate of speed made by an officer. Quote, an officer's estimate of speed is sufficient to support a conviction on a speeding violation. The same evidentiary standard would apply to a reckless driving charge, which, according to Section 40-6-390 of the Georgia Code, occurs when an individual, quote, drives any vehicle in reckless disregard for the safety of persons or property. In the 2003 case of Fraser v. State, the Court of Appeals of Georgia concluded, quote, speeding, unaccompanied by other traffic violations, can form the basis for a reckless driving conviction if the state presents evidence that a defendant was driving at an excessive rate of speed getting close to the speed limit in driving conditions at the time. Considering these Georgia case law precedents, the court would almost certainly find that Officer Brown's testimony regarding her visual estimation of Ms. Webb's speed was sufficient evidence to sustain a conviction for speeding and possibly reckless driving. Although a jury could find that her admission that she did not know the exact speed made her testimony less credible. However, it's important to recognize that this standard is specific to Georgia law. Some other states prohibit convictions based solely on visual estimate of speed.
So, but you can use the fact that you're going whatever speed and she went past you. I'm 10, so you're going to have a back 90. You're going to have 2 cars in position.
I mean, that's unacceptable. I told her, you know the road's wet. You're running late for work and you're going above 80 to work. I said, call. Do not do that. My CAD just froze on me. I'm restarting it right now. What do you think? Or just a ticket? Hold on. Are you? Thank you. Yeah, sorry she did it. My CAD's not working. Who's that?
Yeah, you said in the car.
Okay.
Off camera, Officer Wilson pulls up a coin flip app on her phone and states, quote, A head, R tail, meaning that if the coin lands on heads, then Ms. Webb should be arrested. If the coin lands on tails, she should be released. Regardless of the result, Officer Brown would have been within her authority to arrest Ms. Webb under both Georgia law and the U.S. Constitution. Under Section 40-6-1 of the Georgia Code, most traffic offenses in the state are criminal misdemeanors, speeding and reckless driving. Section 17-4-20 allows officers to arrest individuals for crimes without a warrant if, quote, the offense is committed in such officer's presence. Even if state law did not allow for arrests for these offenses, the Supreme Court has established a blanket rule that if a warrantless arrest for an offense committed in the officer's presence is supported by probable cause, it is constitutionally permissible. In the 2001 case of Atwater versus City of Lagos, the Supreme Court held that, quote, if an officer has probable cause to believe that an individual has committed even a very minor criminal offense in his presence, he may, without violating the Fourth Amendment, arrest the offender, despite noting that the incidents of the arrest in question were, quote, merely gratuitous humiliations imposed by a police officer who was, at best, exercising extremely poor judgment. The Supreme Court later affirmed and expanded this decision in the 2008 case of Virginia versus Moore, quote, warrantless arrests for crimes committed in the presence of an arresting officer are reasonable under the Constitution. While states are free to regulate such arrests however they desire, state restrictions do not alter the Fourth Amendment protections. Given the broad discretion given to officers in making arrests, the court would likely uphold the constitutionality of an arrest decision based on coin toss, as long as the arrest was supported by probable cause. Nonetheless, in some jurisdictions, these actions would violate fundamental policies. For example, Georgia Department of Public Safety Policy Manual identifies certain circumstances when traffic offenders can be arrested, and all other custodial traffic arrests are prohibited. The Roswell Police Department Policy and Procedures Manual, on the other hand, does not specifically limit traffic arrests. It does require that, quote, whenever appropriate, an officer should use alternatives to physical arrest by issuing citations. However, by deciding whether to arrest Ms. Webb based on a coin flip, the officers likely violated another section of the Roswell Manual, which states that, quote, police officers, having a position of trust and civic responsibility, should so conduct themselves as to merit the confidence and respect of the public and fellow officers. Policy also requires that officers, quote, conduct themselves in such a manner as to reflect a favorable image on themselves and the Roswell Police Department. Members will consider it their duty to be of service to the general public, to render that service in a kind, considerate, and patient manner.
Yeah. Sounds right.
Michael Jordan? Hi. So I got two fast. Let me write this down. Reckless?
Yeah, you can and then speeding. And you're just gonna have to mark the pace more.
I mean, either way, the speed limit here is what, 45? She was going way. I mean, because I haven't done one like speeding like that, so that's why I'm a little bit unsure. Can you help me do these dang tickets? My cat won't even log me in. Sorry. Alright, I'm gonna go. Yeah, that's not okay. Yeah. Alright, man. Do me a favor. Step out of the vehicle for me. Calm down. Why? Just calm down. Step out of the vehicle. Turn around. Put your hands behind your back. Because, ma'am, you're driving entirely too fast for your distance. You put a lot of people's lives in jeopardy, okay? Double locking these so that they don't tighten on you. Do me a favor and step in front of my vehicle, ma'am. Step in front of my control vehicle. Do you have anything? Do you have anything in your pocket? Do you have anything on you that's going to stab me? Any drugs, paraphernalia, anything like that? You have a bond. Turn to the side for me. Okay. I'm just gonna shake this out, okay? Do me a favor, step over here. My patrol vehicle. Have a seat for me. We're gonna buckle you in, okay? RDR 390R. Alpha 1 1 in custody. Alpha 1, can you please send me 85?
Here, Officer Brown begins searching Ms. Webb's vehicle. While officers cannot search an individual's vehicle based solely on a traffic violation, there are many instances where officers may conduct warrantless searches of vehicles. First, it's essential to remember that officers can always search a vehicle with the owner's consent. They do not need probable cause to request permission to search. The Supreme Court first held in the 1925 case of Carroll versus the United States, officers can also conduct warrantless searches of automobiles based on probable cause to believe that the vehicle contained evidence of crime without violating the Fourth Amendment. Similarly, in the 1991 case of California versus Acevedo, the Supreme Court concluded that officers can search closed containers inside of vehicles without a warrant if the search is supported by probable cause. However, in this situation, it appears that Officer Brown was actually taking an inventory of items in the vehicle in preparation for its vote. In the 1976 case of South Dakota versus Opperman, the Supreme Court explains, quote, "When vehicles are impounded, local police departments generally follow a routine practice of securing and inventorying the automobile's contents. These procedures develop in response to three distinct needs: protection of the owner's property while it remains in police custody, protection of the police against claims or disputes over lost or stolen property, and the protection of the police from potential danger. For this reason, when officers search and inventory the impounded vehicle, the court concluded, quote, "In following standard police procedures prevailing throughout the country and approved by the overwhelming majority of courts, the conduct of the police was not unreasonable under the Fourth Amendment." Here, the Roswell Police Department Policy and Procedures Manual mandates that, quote, "Members of this department will inventory and document the contents of every vehicle being impounded." Because Officer Brown appeared to be complying with this policy when searching Ms. Webb's vehicle, the court would probably conclude that the search was constitutional.
You can take your phone with you. Now your makeup bags and all that. Is it okay to leave those in the car? You can make a phone call, but that's all you can do. If you want to call them, you're allowed to call them. But okay, give me 1 second. I'll let you call them. Okay? Where does he live? Okay, have a good day, sir. Okay.
Ms. Webb was arrested and charged with going too fast for conditions and reckless driving. The charges were later dropped. On July 18, 2018, Roswell Police Chief Rusty Grant denounced the officer's behavior in a video statement posted on Facebook. It stated that the department was conducting a, quote, "top-down assessment of the department and bringing in an outside consultant from an audit." On July 26, 2018, Officer Brown and Officer Wilson were both fired. Internal investigation was completed. Overall, Officer Brown and Officer Wilson get it for exercising poor discretion by choosing to arrest Ms. Webb and citing her for speeding, violating several aspects of departmental policy and general policing standards, and demonstrating poor character and an overall questionable ethical act. There is no doubt that a majority of Officer Brown's conduct was lawful. However, it can certainly be argued while Officer Brown's actions didn't necessarily violate the law. There are serious ethical questions to be raised about hinging the decision to arrest someone on the flip of a coin. A large part of police work is making the most reasonable and ethical decision possible within the bounds of an officer's authority. Most officers are required to take the law enforcement oath of honor along with their oath to the federal and state constitution. The oath of honor explicitly promotes accountability and maintaining high ethical standards. And officers who neglect to consider the totality of their decisions are essentially betraying this oath and failing to fulfill half of their job description. Officer Brown and Officer Wilson demonstrated behavior that trivialized the social and financial impact of being arrested and diminished the department's relationship with the community. I commend the Roswell Police Department for taking the appropriate action to address their officers' conduct. As for Ms. Webb, I cannot rightfully issue a grade to people who had no control over the dynamics or outcome of this interaction at any point. When Officer Brown initially approached Ms. Webb and informed her that she was traveling over 80 miles per hour, it seemed to genuinely shock her. And Officer Brown later admitted that she didn't really know how fast Ms. Webb was going. This brings the entire stop into question. And there is an argument to be made that no verifiable evidence exists to show that the stop was initiated on a lawful basis. Ultimately, all the charges against Ms. Webb were dropped.